let's get started.
Commissioner Darrow?
Here.
Commissioner Kasher?
Here.
Commissioner Wasserman?
Here.
Commissioner Wynn?
Here.
Chair Remke?
Here. Good morning. Before we get started, I just want to talk briefly about our new website. I hope everyone has had a chance to hop on, take a look, and play around. Staff worked really hard on this, and we're very excited that we finally had it launched. And I just want to give, as I said, all staff worked on it, but I want to give a special thanks to Dave Porter and his entire IT team for getting it actually launched. I would call it a first step because we're going to continue to play with it and improve it. And so if you have any thoughts, suggestions, or concerns, please let us know, and we will take those into consideration as we continue to develop it. So thank you, everyone. Oh, I also should just say SimSoft Solutions was our partner on that, and we really enjoyed working with them as well. Okay, before we get started with the agenda, are there any public comments regarding an item that is not on the agenda? Okay, seeing none, we'll move to item 2, which is approval of commission minutes. Any questions or comments from the commissioners regarding the minutes? All right, is there a motion?
Nope.
No.
Great, I move approval of the minutes.
Second.
Commissioner Darrow?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Remke?
Yes.
This motion passes.
Okay, great. Next, we'll go to items 3 through 48, the proposed consent calendar. Before we do that, do the commissioners need to take any item off consent due to a conflict?
I do. I need to, number 3, I will say I have no financial interest in Ms. Gallagher. However, my firm represents her employer, and this matter is regarding what she did within the course and scope of her employment with Kaiser. So in an abundance of caution and having consulted general counsel for the firm, I need to abstain. So I need to take that off calendar, off the
Okay,
consent calendar.
thank you. Any others? Commissioner?
Yes, this is Commissioner Kasher. I'd like to remove items number 29 and number 30 from the consent calendar. I also need to abstain from voting on these matters. The City of Modesto and the San Francisco Community College District are both clients of mine and my law firm. And I'm currently actively working on active matters for each of those two public entities. While those matters are unrelated to these enforcement actions, out of an abundance of caution, I'll abstain from voting on those items.
Okay, Commissioner Wynn?
I don't want to pull any items off the consent calendar, but I did have a question relating to number 4.
Okay, just let me verify. Are there any others that need to be pulled off before we go to that? No? Okay, please go ahead, Commissioner Wynn.
So on page 6 of the staff report, it just looked like there was one date out of order. 1, 2, 3, 4. In the 5th full paragraph, it looked like there was a final attempt, but it was before the second attempt. And I just wondered if there was just a problem with that date.
Years?
Pardon?
Years?
Oh, the deers, that's what it was. Okay, thank you very much. Sorry, I just missed that. Thanks.
You're welcome.
I just want to, again, not pull anything, but just comment on item 3 and say good work to Zach Norton and Simon Russell. This is the first permanent ban violation case we've had in approximately 20 years, I think. So good work. Thank you. And that's all I wanted to point out.
Madam Chair,
Yes.
I have a couple of just questions, and I don't need to pull these for individual votes. On 11 and 16, it's actually the same question. I noticed there's some redactions. Is that redactions of signatures? I only asked that because the respondents in both of those streamlined cases also had some, sort of guilty with an explanation kind of writing, and I just wanted to make sure there wasn't anything further in there substantive.
Right. Galena West, Chief of Enforcement. That's actually a great question. This was something that we started doing in response to something the chair brought up to us, that if anybody writes anything on their stipulation, that as we present it, it should be presented in its entirety to the commission for your consideration. So those are actually scanned copies. So we did redact the signatures, but nothing else has been redacted.
Okay. And then just in general about maybe a little bit of an update about these cases that are now in 15 to 48, which have progressed from the 50 to the 150. Now we have 204. And could you just bring us up to speed on where we're at on those? It might actually be part of your report later on,
Sure.
but you know, we have these $200 ones and $400 ones.
Well, as you can see in my report, the referral for the 2013 2,460 that we received from the Secretary of State, that we have whittled down to under 87 now. And we are also have received the 2014 referral as of October 22nd, which is another 1,788. And we'll be receiving the 2015 referral in the coming days. What we have discovered out of these cases is that the ones that are currently being processed that you're seeing now that have a higher fine are the people that haven't paid, refuse to pay, and usually have other problems as well, which would be filing problems. So the good thing that has come out of these cases is that all of the non-filers have been brought to our attention through the process. So you're seeing the ones that have said at first, the $50 fee is a bogus fine and I won't pay it, or it's something, some other consideration that they have decided that their committee doesn't qualify for this fee that applies to all the committees. And so now that, to put it bluntly, and so now they're getting the higher fine as they progress through the streamlined process, as they would in any other streamlined process, in order to encourage compliance. And the ones that you get to see on the agenda are the ones that actually do comply. And we make sure that there's also no filing obligations that need to be considered. So these 87 that we have left are the ones that you will probably be seeing on the findings of probable cause in the legal division report, because these are people that are in office, not filing reports, not paying their fees. So those will be very substantial, and you'll get some filings caught up to date for people that are actually in office. So you'll be seeing those in the coming months.
So just looking at your division report and the chart on the $50 annual fee. So you said the 87, those are the 87 still under review, and that's different than the 81 that have been pulled out for prosecution?
The 87 still under review are the people not cooperating. The 81 pulled out for prosecution are the ones that also have filing obligations, or they don't qualify for termination because they have too much money, or they're in office.
So as we talked about before, this has proved to serve a lot of purposes. Number one, cleaning up the database of those committees that should have terminated and weren't, getting a high number off, 2,400 to be. And then in addition, now we're seeing additional fines. So these 81, they were actually active committees.
Correct.
Okay. All right. Thank you. Any other?
And
Go
sure.
ahead.
And you're, like you were saying, you mentioned, and you're using it also as a tool, like a checkup. If they're in for one thing, let's check the ears and the eyes as well. Make
Right.
sure everything else is filed up.
Exactly. And because there's some city clerks that maybe aren't experienced, and so they aren't doing prompt referrals, let's say. So this actually has brought us attention to jurisdictions that we haven't received any referrals for these non-filers, and they're in office. And so it has been great for leads to go into those jurisdictions and educate the clerks and also address the non-filers.
Thank you.
Yeah, and just to reiterate that, we are doing outreach to the clerks as well. So when enforcement sees an issue where a jurisdiction has had whatever kinds of issues, enforcement division will then tell our educational staff who will do outreach and either do a specific training for that jurisdiction, or at least provide the material so that the clerks are being educated as well.
Any other questions for the items remaining on consent? Okay, is there a motion? Yes.
Yes, so I'll move approval of the consent calendars, the consent calendar items 4 through 48 without numbers 29 and 30.
Second.
Oh, actually, let's just hold on the vote for a minute, because Is there any public comment?
Oh.
Okay, seeing none, we'll continue. So there's a motion and a second.
Commissioner Darrow,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. Okay, now one at a time. Item 3, are there any other comments or questions regarding item 3? Any public comment? Is there a motion?
So I move approval of item number 3.
I'll second.
Second.
Okay.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, item 29. Do the commissioners have any questions or comments regarding item 29? Is there any public comment regarding item 29? Is there a motion?
I move approval of item 29.
I'll second.
Commissioner Darrow,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
And then finally, item 30. Any questions or comments from the commissioners on item 30? How about public comment on item 30? Okay, I move approval of item 30.
Second.
Commissioner Darrow,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Great. Thank you, Ms. West. Okay, item 49, this is regarding assignment of a case to an administrative law judge as noted on the agenda. If the commissioners agree with the recommendation, this is a no action item. Do the commissioners have any questions or comments regarding this item?
Yes.
Okay, go ahead, please.
So, with respect to what we are deciding to do or to not to do, if 2 or more commissioners indicate a desire to participate in the hearing would then be conducted by the full commission or along with an ALJ?
Galena West, Chief of Enforcement. Yes, what would happen is the full commission would hear the entire hearing with the ALJ conducting the evidentiary parts.
Mm-hmm.
And if we don't, it will go to an ALJ for a full evidentiary hearing. We'll receive the entire record, and at that time, we can decide whether or not we want to hear any additional testimony, evidence, or briefing.
You'll receive the ALJ decision for approval or changes as you
Right.
did with the prior ones.
With a couple of other cases, and I was just bringing this up because we don't have a great many of these that come up, and it's worth revisiting. What it is we're actually looking at in terms of expertise, resources, prioritization, etc.
Right. This would probably be a 5-day hearing.
All right. Thank you.
Okay, any other questions or comments from the commissioners? All right, then we'll accept that recommendation. Thank you. Item 50.
Good morning, Chairman and Commissioners. I'm Lynn Rodriguez, Senior Commission Counsel with the Legal Division.
Can you pull a little closer just to
Okay.
get that? Thanks.
I'm presenting for adoption proposed amendments to Regulation 18616 related to disclosure of other payments to influence that are filed by lobbyist employers and persons spending $5,000 or more to influence legislative or administrative action. The proposed amendments provide a significant first step in closing a glaring gap in current disclosure rules, one that allows vast sums used to influence legislation and agency actions to fly under the radar without meaningful public disclosure. These expenditures, known as other payments to influence, are currently reported as a lump sum without explanation. And these funds are used for activities that are closely related to lobbying, but do not meet the narrow definition of lobbying. These payments cover a range of activities from paying office rent and office supplies to funding of grassroots campaigns to promote or defeat legislation. Staff proposes more detailed reporting of these payments, disclosing key information about the payee, the amount paid, and the primary purpose for the payments. A greater transparency and more detailed reporting of this information provide the public with effective tools to monitor lobbying-related activity and help promote compliance. The public is entitled to know who is trying to influence public officials and how they are doing it. In crafting this proposal, staff has carefully considered the burdens and benefits in providing meaningful disclosure. We've set forth a straightforward rule that requires reporting of items that lobbyist employers are already required to track and keep detailed records of, and take into account the technological and resource limitations of the current reporting system under CalAccess. Moreover, this proposal incorporates a reasonable time frame, one that allows for sufficient lead time for implementation and provides the public with critical information in a timely manner. We have received a number of comments regarding the proposed regulatory amendments. The proposed changes before you are essentially in the same format as presented at the December Interested Persons meeting, where there were some questions posed but no opposition registered to the proposal. Staff has reviewed the comments that were made and incorporated some suggestions, including modifying some of the payment categories to address some concerns raised. There are a few points that I would like to address briefly based on some of the comments we received. The first is a $2,500 itemization threshold, and we believe this is a reasonable level, and it represents a significant threshold. The legislature has determined that this is the amount this amount is the level that triggers electronic filing of lobbying reports. Secondly, we believe that payments should be itemized for non-lobbyist employees who spend 10% or more of their time in a calendar month in activities related to lobbying. These individuals perform research, drafting, technical analysis, and other support for lobbyists, and may even engage in direct lobbying communications themselves, but they do not qualify as lobbyists. They are not secretarial, clerical, or manual workers, as payments for these employees are specifically exempted under subdivision G1 of the regulation. Also, these employees have to meet a number of thresholds to be included in the itemization requirement. And first is the 10% monthly time requirement, as well as the $2,500 payment threshold. A staff's view is that there are identifiable benefits to requiring this type of public disclosure. Namely, it provides a tracking and compliance function, and the employee is better able to track and confirm the time spent on lobbying support, and the employer who is reporting this activity can verify that the time reported is accurate and the employee complies with relevant disclosure rules. Lastly, staff believes that the proposed implementation date of July 1st is a reasonable time frame. It is one that provides the Commission and the Secretary of State sufficient lead time to implement these changes, and it provides filers with sufficient notice and time to comply. Moreover, it provides the public with crucial information about lobbying activities that spike and intensify at the end of a 2-year legislative session. To close, staff believes that the proposed amendments are a very significant step forward and provides the public with the tools it needs to monitor lobbying-related spending. We believe these regulatory amendments strike the right balance, and it is a first step in this area. And if approved, staff intends to monitor these reports and propose modifications as necessary to ensure that adequate and relevant information is being disclosed. And staff recommends that the Commission approve the proposed amendments to Regulation 18616.
Thank you, Emmeline, and thank you for all your hard work on this and dealing with all the interested persons and trying to address the concerns. Obviously, we have carefully reviewed all the public comment on this, and I know that you and Hyla work to try to address those. One of the overriding issues in this area is the balancing. Obviously, we want as much information as we can get, but meaningful information, and meaningful information under the existing system, which we all know is very limited. So we had to work closely with the Secretary of State's office on this issue, which has been over almost a year now of trying to even get to this point. So the idea that so much more can be done is just not realistic, unfortunately, at this time. So again, I really think that you guys have struck the right balance, and I appreciate that. Any other questions or comments from the commissioners? Oh, we will.
Yeah, before I
Oh.
have a couple of
Okay.
comments, but I just assume we.
Do you want to?
Yeah, that's fine.
Okay, it sounds like the commissioners want to hear from the public before they address their questions as well. So public comment, let's go ahead. Good morning.
Good morning, Chair Remke, members of the Commission. Nicholas Howdorn with California Common Cause. Common Cause is pleased to strongly support the proposed recommendation to amend the regulation. There's an article in Cal Matters where Bob Stern was quoted about when he was working originally on the PRA, he'd never envisioned the type of grassroots funded lobbying that you would see today. But what we know, especially from the staff report and other news articles that come out, that for many of the top interest groups that do lobby, this has now become, in some cases, the bulk of their spending. The FPPC report mentioned around 70% of the spending for some of the top interest groups. We think this regulation is really important to modernize our lobbying disclosure regulations and to bring them up to date with the realities of lobbying today. So we are pleased to support this and commend the FPPC for its leadership on this issue.
Thank you.
Good morning, Chair Remke and members. I'm Trudy Schaefer, representing the League of Women Voters of California, and we also are very pleased to support this measure. I would echo all the statements of my predecessor from Common Cause, and want to just say that we're very pleased because it's up to you as a commission and up to all of us who are watchdogs on the political process. But it's very difficult if citizens cannot find out who is behind payments and what those payments are. And we've had multitudes of examples now. We particularly were involved in legislation over the summer where one of the most egregious examples of itemized special payments to influence were made. It was something that people probably on both sides of the issue were scrambling to find information about. And we feel that there's no way that the average citizen can understand the pressures that are made on the policymaking process unless we have this kind of itemization. Thank you.
Thank you.
Thank you, Madam Chair and members of the Commission. Nikki Moore with the California Newspaper Publishers Association. And we would like to first applaud your response to this glaring gap in disclosure. Clearly, if there's millions of dollars being reported with no itemization, then there's no meaningful public information about what that money is being spent on. And newspaper reporters analyze this information so that they can provide the public with that information. So we think this is a great move and we support it very strongly.
Thank you. Additional public comment.
Good morning, Diane Fishburne, Olson Hagel and Fishburne. I submitted written comments to you, and I also worked closely with staff during the interested person process in providing our comments and suggestions. Our firm represents a whole gamut of filers who file reports under the Political Reform Act, ranging primarily from a large number of nonprofit organizations, including 501c3 organizations, unions, and other nonprofit trade associations, etc., as well as other types of filers. We prepare numerous reports and we are very familiar with the lobbying requirements. And our comments today are not focused or submitted to you in opposition to the overall purpose or intent of the requirements. I think I've been saying to my clients for about 10 years, this is coming, get ready. So I don't think it's a surprise to anyone. However, I think, as I explained in the letter, we do have some very specific concerns about kind of the reach of the reg. And I think what the chair referred to earlier in terms of the balancing, I think that you need to do in imposing new requirements on filers with the commensurate burdens. And also, I'll speak separately on the employee issue, but I think it's important. And I think also, and this is already been referred to this morning, but the importance of meaningful public disclosure that is a goal here as well. And so on that point, I think the threshold, of course, at some point, it's a number that the commission is going to pick. Staff has suggested 2,500. I think 5,000 or 10,000 would be, in my view, much more a reasonable approach here. If what you're trying to get are the payments for advertising, for example, that Common Cause referred to, or payments to outside consulting firms, you're going to capture those at a $5,000 or $10,000 threshold, and that's seems to be the important information that we're looking for here.
Can I jump in and just ask, how do you balance that against the current requirement for local and state government agencies that already have to provide this information at $250?
Yes, so that's under the statute that the legislature made the determination that public agencies, and I think it's obviously taxpayer-funded agencies, did have to provide disclosure at lower levels. That's true.
I'm just saying, I hear your concerns that we may be getting too much information, it sounds like you're saying, which I think the staff's thought, and I would have to agree, is that it's definitely easier to start lower, and if we get too much information, we can revisit it. It will definitely be harder for us or any agency to go to 10,000 and then come back in a year and say, oh, actually, we should have gone to 2,500. So since this information is already required under the law to be itemized by these groups, the issue of just putting it onto another form, I think we'd rather see that now and then revisit the issue of the amount. That's my position. And again, I think if the local and state government agencies have to do it at $250, and I've yet to ever hear a complaint on that as too low, I think we might be hitting the right balance at 2,500. And then my last thought on that would be, if we were to raise that in any amount, it would make the employee disclosure almost obsolete.
Well, why don't we talk about employee disclosure then?
Sure.
And I think what the staff, again, is proposing is to include a requirement, or to include within this requirement, a requirement to list in-house employees if their salary over a 3-month period is $2,500 or more for that percentage of their time that's in support of state lobbying activities. And I think we made the points in our letter, but I think there are some privacy concerns for employees in having their names disclosed and their salaries disclosed, which is, by the way, not currently required for lobbyists, which is kind of an interesting contrast. And maybe you want to go back and do that for lobbyists, but I think at this point to have greater disclosure for non-lobbyist employees does seem a bit odd or out of sync. The other thing, in terms of the meaningfulness to the public and the disclosure of employees, it seems to me what's important there maybe is how much is being spent by a particular organization, but knowing that it was John Smith that did the research on some comments that were submitted on a regulation seems to me not as much interest to the public. And also, I would note, this is limited to in-house employees. So if someone were an independent contractor or consultant, they would still fall within the requirement.
They would fall under the category of consultants in government relations.
Right. They would not come within any kind of employee.
But they would still have to be listed under the other new category with
Correct.
their payment as well.
That's correct.
I just want to air this a little bit because I understand the concerns you're raising about, well, I guess I should say I don't really understand the concerns you're raising about privacy. Is it that the salary will be disclosed? Because as you know, if you step back and do the math on this, we really will have no idea what an individual's salary is, because we're talking about 10% to 100% of their time based on this amount that's disclosed over 1 month or 3 month period. So really all we're doing, and as was mentioned earlier, is forcing the employee to keep track of their time accurately, because this has been an ongoing issue, and the employer to disclose that amount. And again, it's for the compliance as well as to facilitate with enforcement. So while it is definitely a move, the issue is how better to track it than if someone knows what they are tracking of their own time is going to be publicly disclosed. I mean, to me, that seems to be the best indication of compliance.
Well, I think that the compliance and tracking that purpose can be served by requiring the reporting that's required now, and the records are there now, and in an audit, those are reviewed at that time. And the obligation is on the employer to ensure that, not necessarily the employee, because the filer is the employer, not the employee.
But the employee obviously is the only one knowing what they're doing and how they're spending the time. And as mentioned, a lot of this activity is in fact lobbying, direct communication. In fact, it can be up to 32% of their time that we're going to be looking at, because it's the 33% that triggers it into a lobbyist. So again, if we're talking about 32% of someone's time with direct communication, and we've all heard the stories of who's over at the Capitol, what they're doing, why are they here so often, but yet they're not a registered lobbyist. You know, this is to get behind the stories and look at the facts. So that's the goal here.
Right. And I think in the situation you just mentioned of folks who are at the Capitol, that are observed at the Capitol and perhaps are not registered lobbyists, that I suspect that at least 90% or more of those would be individuals who are not employees of an organization, but who are,
I guess we'll find out
contracts or consultants. I guess we will if you proceed as proposed.
Okay, was there anything else?
No, I'm happy to answer any questions.
Yeah, I had a question. After you, Commissioner.
So I represent employers, and so I understand what you're saying. As I know that my clients struggle with the concept of they take personal information from their employees that their employees are required to provide, name, address, all sorts of private information. But employers struggle with the idea that this private information is for purposes of employment only, not to be divulged to the public. And I'm concerned that employers who are now going to be required to identify by name and address an employee. I'm sorry? Okay, that's better. But by name and the identity of a person who may not want their name disclosed. And so I just wonder, I understand, I'm trying to find the right balance between, I get the issue of who's at the Capitol and who is making, these comments and who is trying to influence, versus somebody who is sitting behind a desk, has never gone to the Capitol, and suddenly their name is being made public just because part of their job function is to work on a mailing. Or I'm struggling with that, and I'm coming in at the tail end of this, so I'm hoping you can educate me on that.
Yes, well, we think it will help with compliance and tracking, and I guess especially in the case it's the in-house lobbyist qualification is this spending 1/3 of your time in direct communication. So it's a very high standard, and basically not very many people spend 1/3 of their time in direct communication. No legislators want to listen to anyone that much. It's just, it's kind of so it's a high standard. So to the extent that some of these in-house, many of them may just register because they are the lobbyist for an in-house for a company. But here, if people, this may have the names of some of those people who are in effect an in-house lobbyist. And there are also the people providing the lobbying support, like you say, but it's just the name, it's the business address. And it probably will help with keeping the recording of the time more precise than categorizing it in a lump sum for all employees or just in a lump sum as it is now, other payments to influence.
And I would just add to that, again, let's step back. The current statutory requirement is that all payments to employees who spend 10% or more of their compensated time in 1 month in activities related to influencing legislative or administrative action. Again, we're really focusing on people who are doing things that influence legislative or administrative action. We're not talking about, again, the clerical, the behind the scenes, the removed people. And there is the 10% threshold in a month of their time on this, that very narrow type of activity we're talking about. I think that perhaps this category is one of the most fundamental purposes behind this proposed regulation. As we've said, and I'll say again and again, lobbying is largely a self-regulated industry. And in order to make sure that people are playing by the rules, we need this type of information, and it puts a light on what is going on. And again, it's self-regulating and then enforcement facilitating when that activity is not being done properly. So any other questions from the commissioners on this?
Sure. Yeah. So thank you very much for your thoughtful letter. I was surprised, frankly, with this item, how muted the opposition was. And I mean, I really appreciate staff work, because you must have done an awful lot of work with groups to get to this place. So you raised the issue about the $2,500, and I don't know if it's $2,500 or $5,000, what's the right number, but I'm comfortable starting with a $2,500. And if we get too much information, or if it really just seems really too low, I think we can revisit it. And you also asked for a delayed implementation, but I'm reluctant to do that, because we would miss the whole second half of a 2-year session, and in an election year. I just feel like it's critical. But I have a little level of discomfort with the employee disclosure. So I was a 30-year public employee. So my salary was public, my information was public, my Form 700 was public, and I was always comfortable with that. But I had elected to become a public employee. I am a little reluctant with someone who's in the private sector disclosing information, but we're really, I think, only talking about people who spend between 10% and 32% of their time.
Well, it's actually 10% to 100% of their time related. The 32 issue is the direct communication trigger. But again, these people could be spending 10% to 100% of their time influencing legislative or administrative action. And I think that's where the issue, just like lobbyists, and as Hyla pointed out, part of this issue is for us to understand, do we have the right balance now on when you become a lobbyist? Should it be only direct communication? Should it be a third of your time? Is that such a high hurdle that we are missing a lot of the key players in this game because they don't meet that very narrow definition of lobbying? Again, I think our goal is to see what information we get. If we get a laundry list of people who are doing what some people are saying, just sitting at their desk researching, we can revisit this issue. I don't think that's who we're going to get in this category. I think we're going to get the people like the former members who leave the legislature early, join Chevron, join pharmaceutical research and manufacturers, but call themselves government relations advisory, government advocates, but we know what they're doing. They're exposing their clients to the members and doing other things short of, quote, direct communication at 33%. So again, I think this is perhaps the most important element here. I think the names, when you step into this job and you know your job includes influencing legislative or administrative action, just like a lobbyist, you know that you have a potential to have your name triggered. I mean, again, as soon as they hit 33%, their name is triggered.
Mhm.
So it's that fine line. Where are we at? And again, as far as the salary goes, you know, anyone that works on staff can say, I've played this game for about a month now, and it's virtually impossible to tell how much someone is actually making as a salary, but we do know how much they're getting paid for this portion of their work within a quarter.
I could just make some additional comments. I appreciate that. I would like to note that on the 10% or more employees, we're not talking about necessarily the same employees every quarter, because employees who are not the ones who are the lobbyists for their organization may get brought in on a different regulatory question or a different legislation. So we're talking about a revolving list of employees, not employees whose principal and regular duties are to lobby, because that's the definition of lobbyist in 82039. These are folks who have other jobs, but who are brought in to support or to work on particular projects. So this is a revolving list. This is not necessarily the same people. And I work with a lot of large nonprofit organizations in particular. So depending on their activities, different folks may get called in. And on the question of former legislators or other folks or other consultants and where would they be disclosed, they would not be disclosed in this category unless they were actually employees of the filer. If they were employees of a consulting firm, which I think is more likely the case, they're not going to be disclosed under this rule. If they're employed directly by the filer as an independent contractor, as an employee, they're going to be, the payments to them will be disclosed as activity expenses on their Form 635, because payments made to anyone who's currently a candidate or holds an office. So unless the person has no committee open and is no longer a candidate, they will also potentially be disclosed as an activity expense. So I think with this category is, again, focused on the employees who are supporting other lobbying efforts. And yes, they may be engaged in some direct communications. They may sign a letter to an agency, for example, in a regulatory matter, but they don't qualify as lobbyists.
Any other questions? Thank you. Commissioners have any other questions for staff on this issue? Is there a motion?
Sorry,
We
do.
Oh. Okay, again, coming in at the tail end of this. And I want to say, Hyla, thank you so much for the time you took to kind of bring me up to speed on some of these issues. But I do have a question on the itemization part of this. So as I understand it, the payments that are made to the lobbying firms, those just have to be reported as totals, correct? Yeah.
Right.
Okay. And the payments made to lobbyists are reported as totals, correct? No itemization.
No.
So it's only the payments made by the filer to influence that if they hit 2,500 or more have to be itemized.
Correct, under other payments.
Right. Okay. So my question is, doesn't this mean that itemization is triggered by who makes the payment, right? So if the filer is making the payment, there has to be itemization. If the lobbyist is making the payment, there's no itemization. What's to keep the filer from saying to the lobbyist, I'm not fronting this money. You front this money, because if you front this money, you bill it to me as an expense. I don't have to itemize it. Am I misreading this? And then there's no itemization at all. So it seems like there's a way to circumvent this. And I went and I looked at Form 615, which I understand is the one that the lobbyists have to file. There's no itemization requirement there. Their Form 615 is just name and address of the payee, I think. And there is no code. So what am I missing here? And I'm sure I'm missing something, but I just want to make sure that there's no like easy way to circumvent this.
Well, I think usually the lobbyists are just being paid by the client. And so they're not making the other payments to influence. Maybe they're doing activity expenses, and the lobbyist employers and these other entities, $5,000 filers, might be making the payments to the lobbyist, making payments for grassroots campaigns. They're making a broader range of payments, including other payments to influence.
Yeah, I would say, I think if I'm understanding the question, it's the type of activity, which again is the big picture behind this, as has been stated in some of the articles you probably read. And as someone mentioned earlier, when the Political Reform Act was first drafted, the notion was that people would be paying lobbyists to lobby to influence. But with the shift in time, we see this other category of activity. And so this is about activity, not who I'm paying. It's about what the payments are being directed at. And again, in a big picture, we're looking at, are they directed at in-house employees? Are they directed at the ad campaigns that have been mentioned? So again, you wouldn't have a public affairs grassroots media campaign performed by a lobbying firm. So it's the type of activity we're talking about.
Okay, right. So that's my misunderstanding. So it's not possible then that a lobbyist firm would then take on this grassroots activity and then just bill it as an expense reimbursement, which doesn't have to be itemized?
Well, it's quite possible that might become the trend. There's still going to be lobbying. We're still going to see where the money's going. I mean, right now, some of the issues are what happens is there's a division, and I let one of you talk to this more, about big picture firms with a public affairs branch and a lobbying branch, but the payments are separated so that the public affairs people don't become lobbyists. So again, we'd still see the breakout under this proposal.
Where would we see that?
Because all the money that would go to the public affairs now falls under other payments to influence, but now we're going to see the breakout.
Oh, okay.
That's correct.
Commissioner Wasserman, did you have a question?
Sure. Yes, thank you. You know, actually, two of the questions I had, I think Commissioner Adair put forward, and the last point reminded me. So I have two questions here, and they're sort of diametrically opposed philosophically. One is about how far we go, is it too much, versus how far we go, is it too little? The conversation about the statutory law, thresholds for determining, the direct communication and lobbying, does that restrict us in any way about what we're doing here? I mean, we're attempting to extend ourselves and get as much information as possible, and we are attempting to construe the statute as liberally as possible to effectuate its ends. But at what point do we say, hey, the statute says this is what we're doing to trigger this point? We're trying to scoop up a whole another zone.
Well,
interruption. This is Selena with AT&T Teleconferencing. Mr. O'Brien, are you on the line?
Patrick O'Brien is not on the line right now.
Okay. I have a customer. I have one of your participants on the line wanting to know, are you all going to allow?
You're going to need to call us back in an hour.
No, we're not going to allow comments over the phone. Thank you.
Okay. Thank you. Have a great day.
Do you have,
Yeah, we have solid statutory authority to require this type of information. Under 86116, there is a provision that says that we can require information that's consistent with the purposes of that section. So, we don't feel that there's a question about whether or not we can require this information. It's just, you say the balancing, trying to not scoop too much in and having relevant information that we're trying to gather. So that was something we looked at, we were sensitive to, and felt that the section does support what we're trying to do with this regulation and what the purposes are of the act.
Well, can I go a little bit farther than that? I'd also just point out, I think you raised a really good point, though, because interestingly enough, the definition of lobbyist has the broad term for in-house lobbyists that their principal duties are the direct communication. We, as a commission, have defined principal duties. So right there, we have pretty broad authority, and we have set it at 1/3 time direct communication. And again, a goal behind this is to see, are we at the right line? Have we as an agency gone too far in putting it such a high, as Hyla pointed out earlier, the ability of people to meet that, it's pretty tough. 1/3 of your time direct communication with public officials and their agents. So I think, again, we're saying, did we initially as an agency set it at the right amount? And I hopefully will see that based on who else falls under the other activity to influence.
And the statute already, it requires the reporting of direct communication under definition of lobbying, and it has already scooped in all these other payments to influence. So it has already required the reporting of that, and we're just asking for the breakdown.
Yeah. Okay. So we're refining some things there. On the far other end, and I think it may tie in somewhat to Commissioner Darrow's question. Somewhat, I could be wrong, but the question of sub-vendor disclosure, etc., because I think that might get to some of what she's talking about. Is that really something that is more appropriate in a different regulation?
We're not doing sub-vendor,
but
you're saying, should we?
Right. Like I said, I've just switched to the. That's why I tried to give a heads up that I'm going to go from one end of the spectrum in the question, from the question of restraint, to the question of whether or not something is.
Again, I think the biggest issue is our inability to even go down that path at this point in time, because of the restrictions of CalAccess and the creative solution staff came up with to get us to this point. And as you know, there are categories with one letter descriptions in brackets, and that's about as far as we could go. So the notion that we're going to then have sub-vendor information is just not at all practical. But I would say, again, looking at the goals and purpose behind this, do we even need that information? What we are trying to do, again, and look in the big picture, is the way we've defined lobbyist, what falls on under other payments, the change in tactics we've heard about. If we can get some big picture understanding of consultants, public relations, public affairs, then we say, as some concerns have been raised, did we get enough information? If we did not get enough information, what it's going to do is help us when we talk about building a new CalAccess and where we go. You're smiling at me.
Well, I'm smiling because I think we're demonstrating that, these are conversations that we have out in the open, in the public. Otherwise, they wouldn't be happening here because we're not allowed to have them elsewhere. So, so that what I was particularly smiling about, that and the fact that I saw the mighty pen of must instead of shall throughout this regulation. Which, etc. That's fine. I have one other question, and this goes back to one of the challenges in regulating, the challenges of language. So, a couple of years ago, I went to a training that the agency was doing for filers, for campaign treasurers, etc. And there was a woman in the back who was an accountant. And she was asking about disclosures for expenditures and contributions. And she asked, I'm a little confused. She goes, is this cash or accrual? And I had to sort of jump up and say, well, neither and both. The form is what the form is. The reg is what the reg is. This form asks for something on a cash basis. This one asks for it on accrual. Similarly, I'm looking at page 5. Which is 1B. I think it's part of 1B. And it says, including about what would be disclosed, other expenses that would not have been incurred but for the filer's activities to influence or attempt to influence legislative, etc., including office overhead and operating expenses payments to expert witnesses, etc. And then it goes on to say, however, any expenses associated with office overhead and operating expenses should not be itemized, but listed as a lump sum. But so we're not truly talking about office overhead and operating expenses in any sort of accounting sense. We're talking about this again in the sense of how we regulate, because we've said certain portions of salaries are going to be disclosed separately if they meet the thresholds for actual behavior that trigger things.
Right. So what is the question? Let's back up a second, because the problem with overhead expenses has been one of the issues and challenges since this category has blossomed, and people saying, oh, it's all off overhead and expense. We don't really care how much someone is spending on rent, but the statute requires them to disclose overhead expenses. So the point, and following the form we're going to use, 640, says, okay, lump all those expenses that we don't really need a breakdown into one line. So that's what this is going to do. Same thing, because again, that's how the form is, and it actually, in fact, it makes the most sense.
So in that process, and I don't know if the chair knows this part of it or not, because it's sort of down to the nitty gritty, are salaries then still going to be, are they going to be lumped into overhead expenses in one place, but then disclosed portions of those separately in another place if they cross this 10% threshold? Or are salaries completely excluded from overhead and operating expenses as we understand the term?
I think they're a separate category. They're excluded from overhead and operating. And for example, the lobbyist employer under G2, they don't report their regular overhead expenses as other payments to influence legislative or administrative action. If they opened a separate Sacramento office, for lobbying, then that overhead expense they would report as other payments to influence. And we're saying you'd put it in this lump sum category.
Right. Okay.
But I think the employee salaries are separate.
Last one. Page 2. Under C, payments to lobbyists, this language I'm going to refer to repeats elsewhere as well. A lobbyist salary does not include routine fringe benefits that are made on behalf of all employees.
And this is existing law, as you know. We're not changing this. We just changed the placement of that.
So the language has just been moved around. Is that what's occurred here?
That's all that's occurring in subdivision C.
So if there are any employees that are not receiving the same fringe benefits that the lobbyist is receiving, or maybe receiving a different level of the fringe benefit?
This is payments to lobbyists.
Right.
Okay.
Correct.
I'm sorry. I don't.
Is there some sort of requirement of equality across the board for these employees for fringe benefits in order for this to be triggered, or
it seems like
to be included or not included?
But it seems the same on page 4.
Right.
For the compensation of employees other than lobbyists. It's just basically saying you just report their salary, but not all the costs of their health care and,
And no
benefits
fringe
don't-
benefits are required to be reported
for lobbyists or
for lobbyists or
employees.
regular employees.
I'm sorry.
The fringe benefits aren't required to be reported
For
as part
either.
of a salary for either.
So they're basically saying, look at the definition on page 2 compared to page 4 of what salary is for a lobbyist or other employee, and they're similar. So it's just stated in 2 different places.
I'm sorry. Commissioner, did you have a comment, Commissioner Adair?
I think you're saying something different. I think you're saying that what has to be what is a payment to a lobbyist? And a lobbyist salary doesn't include fringe benefits if they're routine and made. It's the same fringe benefit paid to all employees. Isn't that your issue? That if there is if not all employees are paid this fringe benefit, which can easily happen, right? Because you could have some part-time employees who don't get benefits at all. right? So in that case, would then the fringe benefits be reportable as lobbyist salary? Is that what you're saying?
Thank you, employment
Okay.
specialist.
Again, I guess I
Assuming
would,
the answer is yes.
Yeah,
Right.
if it's a fringe benefit that's not available to other employees, yes, it's part of the salary.
So this is really something that if they haven't been watching, they need to watch that as well. If they have a part-time employee who has different fringe benefits, does not receive the same. Well, I'm not even sure if it's the same level of
Right.
fringe benefit, maybe the same classification. Then they're going to be triggering that additional amount of information that needs to be reported.
Right. And that's been in the regulation for a long time. Like if that person got a car, but most people don't, then I guess that would count or something.
Okay, thank you.
Commissioner Kasher, do you have any questions on the regulation for staff?
I do not have any questions. I do have a comment, and that is that I support the proposed amendment as presented. I want to thank staff and the chair for taking up this issue. I think that the chart in the discussion has been, the chart in particular and the amount of money that's being, kind of spent in the dark is extremely compelling, and those numbers are compelling. I think that this is one of the more important amendments that we've taken on since I've been on the commission. I did have an issue and a question regarding the disclosure of information related to employees, and I want to thank the representative from Olson, I believe, for the comments on that. But I've been persuaded by the chair's and staff's explanation of that issue. So no longer I don't have any questions, but I do support the proposed amendment.
Okay, thank you. Is there a motion or do you have a question? Is there a motion?
Yeah, I'll move it.
I'll move to adopt the proposed amendment to Regulation 18616.
Second.
Commissioner Adara,
Yes.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. Thank you, everyone, for that discussion. And I'll just point out that we will bring this back after the first reporting period of October and share with you the information we've gathered and do an analysis and see where we're at. Thank you again, Emmeline. Okay, we have the staff reports. We've heard a little bit from Galena West already. And Erin, you were just going to mention on the legislation issue.
Right. So as you probably noticed, there was no ledge report in this agenda package. And that's because obviously the legislature is, as we've mentioned earlier, in the beginning their second year of a 2-year term. They just came back at the beginning of this month. So things are in a bit of, well, more than a bit of flux at this moment over there in the Capitol. So there are new bills being introduced as we speak, and there are also some questions about 2-year bills that held over from last year and whether they're moving them forward or going to gut and amend or whatever other variety of topics. So anyway, the bill introduction deadline is February 19th. The requirement to have language into Legislative Council is tomorrow. So we will have a much better picture of what's going on in the next few weeks. And we'll also be preparing the normal ledge report for the commission for our February meeting.
Thank you.
Madam Chair.
Yes.
So with the deadline to submit language, are we primarily focused on things that we already know are coming down from the legislature or 2-year bills? Are there any new things that the commission is attempting to put forward in this second year?
I think this year we're really focusing on the types of regulatory packages that we just were discussing. And also because this is an election year, we have some concerns obviously about doing any legislation that's especially related to campaigns. So that's sort of a long answer to your question, but I think we have a couple sort of smaller ideas that we might be talking to authors' offices about at some point. But generally, we'd like to implement the legislation that was passed last year, which we are still in the process of doing, look at regulations, and also kind of focus on obviously all the enforcement and advice questions that'll come from the election. So, and we have made that already clear to leadership over in the Capitol that we would have concerns about especially major legislation coming through in the middle of an election year. And so we'd like to, we don't like to change the rules in the middle of the game.
Thank you.
Other questions regarding, oh, go ahead, Commissioner Kasher.
Yes, Madam Chair. I had one comment on the outreach and training section of the staff report. I just wanted to thank Heather, Hyla, and then staff more broadly for participating in these outreach trainings. We've been very active recently in in amending our regulations, which is great. And I think a big component of that is following adoption with education and educating the regulated community on all of these changes. So thank you to staff for taking the time to do those trainings and for getting and helping to get the regulated community up to speed on some of these changes. And I hope that we continue to do more of these in the future. And I think that that's a wise use of staff's time and resources.
I would agree, and I'd also just like to thank Trish and her staff as well, because under the Technical Assistance Division, we have additional highlights about all the work that's been done and the outreach. So, and we will continue that, and you'll see a more comprehensive overview of everything we did in 2015 in our end of year report, which will be coming out shortly. But thanks to all staff for their efforts on that. Other questions?
Sorry, we're dealing with the staff reports as a lump at this point. So, okay. If I may.
Yes, go ahead, Commissioner Wasserman.
I was curious. I know we had discussed this previously about, and it actually came up today as well, about the process of educating city, county clerks, other filing officers when things tend to pop up. Do we have something scheduled, or has it already occurred for when we're swinging back by to San Bernardino County? Because I think we had talked about how there are opportunities there.
Right. We are in the process of working with representatives of the county to figure out what the best resource allocation is, but we will definitely be having staff on site, hopefully in the next couple months down there, to train as part of the agreement that we have with the county, that particular county, to educate their campaign treasurers and candidates. And we are also going to be doing, so we will have people on site, but we also are doing a specific web page on our website specific to the issues that are related to their ordinance. And we have sort of outlined with county staff our plan for the entire election period, including efforts enforcement will be taking, and our education staff to work with the candidates to really train them up on all the requirements.
I think that's an excellent idea to have something very specific for that, because it is a discrete obligation that we have to deal with them.
Well, and we having now been through that a 2-year cycle with that particular jurisdiction, we've gone through and sort of done lessons learned in terms of the types of violations we saw repeated, and we'll be specifically targeting our education outreach to address those so that we can try to prevent those types of violations from occurring in the future.
Great. Then I just have the question to the budget memo. If
Okay, go ahead.
Okay. I'm very appreciative to see this budget update this month. I know that the way...
You know ways to spend the $8,000.
Sorry?
I said, are you trying to think of ways to spend the $8,000 possible surplus if nothing
No,
happens?
actually, I wasn't.
Nothing goes wrong in the next 6 months? Exactly, but the water did not work earlier this morning, but...
He's speechless.
No, actually, I'm not. But I'm just
kidding.
No, I'm not. I'm not looking at that number. I'm just appreciative of this presentation. I know that the methodology by which budgets are determined for this agency, it follows a particular path through the executive director, et cetera. And of course, we don't really control revenues or things like that, because essentially it's what we are given,
right.
And particularly in this budget climate where sort of the attempt is to hold all numbers down. But I think it's just useful for us and for the public to sort of see these numbers, and if they have questions, to inquire further. But it just sort of shows in another sense, how much we have to do and how relatively little we have to do it with. And it's interesting also because when our budget numbers come up and they show this number related to, for example, San Bernardino, one of the things that Ms. Hahn has been very helpful to me in explaining to me is that when that budget number is there for San Bernardino, it's sort of like a contract not to exceed number. It doesn't mean we get that money. It means we do work that would be compensated under that. So in a sense, we actually have even less than what a number might show on paper to work with, and even more to do to get to those numbers. So I appreciate the work that was done, and I thank you very much.
You're welcome.
Okay, are there any other questions or comments from the commissioners? Okay, then I'll move to adjourn the meeting.
Second.
Commissioner Darrow?
Yes.
Commissioner Kasher?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Nguyen?
Yes.
Chair Remke?
Yes, thank you. Thank you, staff.